I'm Daryl York. I'm a 24-year retired police veteran. I'm now a criminal defense attorney. In California, if you walking down the street and you bump into somebody and you have some fighting words or you challenge them to fight, you can get charged with 415 of the Penal Code, which is disturbance of the peace. You think in the United States you have free speech rights. However, you don't really if you're going to challenge somebody to fight in public or use words that are offensive, that are likely to produce a violent reaction. So be careful what you say when you're out in public because you can be arrested and charged for that offense. If you're playing your stereo too loud, you're having a good time, at your house having a party, and you're rocking away, and your neighbor doesn't like that, they call the police, they show up at your door, you can go to jail for disturbance of the peace. 415 of the Penal Code in California makes it illegal for you to create loud or unreasonable noise. The question is loud and unreasonable. Probably the most frequent calls that I would get as a police officer on a Friday or Saturday night is loud parties. And we go knock on the door and tell them to be quiet. The problem with disturbance of the peace, at least from a law enforcement perspective, is you need a victim. And if the victim is not willing to press charges or place a person under citizen's arrest, there's not a whole lot the cop can do. He can't really be the victim of that crime. So usually, at least when I was an officer, I would make sure that I had a victim that was willing to push the issue. If they weren't, I'd tell the victim, don't call back. But can you get arrested? Yes. And what has happened in the past is the officers will come in and they'll confiscate your stereo, whatever is causing the loud music, so they can bring it into court. They'll book in evidence. I don't think you want to go through that, so it's something to consider. If you're having a loud party and they come knocking at your door, you may want to turn it down. Many times, individuals that are charged for battery, domestic violence, prostitution acts, lewd conduct, we're able to get that charge reduced to a disturbance of the peace. Disturbance of the peace is a low-grade misdemeanor. It's a wobbler. It can be an infraction or a misdemeanor. And it doesn't carry the stigma that these other charges carry with it. A battery charge also prevents you from owning a firearm for 10 years in California. I don't think you want a prostitution or lewd conduct on your record either. So we're able to sometimes negotiate that charge down to a disturbance of the peace, which when you look at your arrest record, it's like, well, I was making a loud noise. Or maybe I was challenging somebody to fight in public or using bad words. And sometimes we're able also to get it down from a misdemeanor 415 to an infraction. So that's the beauty of having that charge, because it's one of the few ones that can be reduced to the infraction. And as an infraction, it's not really considered a crime. It's like running a red light. So it can't be used in deportation proceedings. It cannot be used for a job application. They ask you, have you ever been convicted of a crime? Well, infraction is not a crime.